So hello, everybody. My name is TJ Scott, and I am the owner of the law office of Timothy J. Scott. I'm an estate planning attorney, and that means that I help people to avoid court and conflict in their families after something happens to them, meaning either they become incapacitated or they die. And it's a sad fact, but we are all going to die someday. And you have showed up here with me tonight, acknowledging that fact and taking ownership of it, and educating yourself and empowering yourself so that you can deal with that reality. And I've got to tell you, I am so happy to have so many people joining tonight. This is a fantastic turnout. And I know that we're going to be talking about this difficult topic tonight. But again, I just want to thank you for being here and facing it head on with me. Knowledge really is power. And that's what I'm seeking to do, is to empower you on this topic so that you can take control and that you can make sure that your family is taken care of in the very best way possible, in the way that you know that you would want your family to be taken care of. And so that's what I'm going to do tonight. I'm going to empower you. I'm going to give you some peace of mind around this topic. And I have a ton of valuable information that I want to share with you. Again, with some valuable offers that I'm going to be sharing at the end of the presentation. So make sure that you stick around for that. Okay, let's dive in. The best way to learn is to be present with me here tonight. And I just encourage you to take this time that you've set aside at 7 o'clock on a Wednesday night, a wet Wednesday night here in Minnesota, to turn off the distractions and really be with me. Give yourself this time. Give yourself space to learn. And I can tell you something that I always say, your future self is really going to thank you for taking this time to educate yourself and empower yourself on this topic. Again, if you stick around until the end, I have some great offers that I want to give you. The first offer that I have is a free virtual one-on-one meeting with me, where we're going to talk about the things you have and the people that you love, and exactly how you can take control and protect them. Plus, I have a bonus gift that's going to make it even easier to get a personalized and tailored estate plan in place for the people that you love. Before we get too far ahead of ourselves, I do want to ask this question. And the question is, do you have an estate plan? I'm going to put a poll up and I will be able to see the results as they come in. Do you have an estate plan? What I have here are all pieces of an estate plan. A lot of people think when they hear estate plan, it means a will. Do I have a will? Or it means, do I have a healthcare directive and a power of attorney? But really, an estate plan is more than just one document. It's more than a set of documents even. An estate plan is composed of things like a trust, a will, guardianship nominations if you have minor kids, healthcare directives, powers of attorney, beneficiary designations. But it goes even further than that. And I am seeing most people tonight are responding no. And let me just tell you, it's okay. I understand. If you don't have an estate plan in place, I completely understand that there are a lot of things that can get in the way. Maybe one of these resonates with you. First off, thanks for responding to the poll if you did. But I'm going to pop another poll up here as well. And the question is, if you don't have an estate plan in place, and I saw about 50% of the people who responded don't have an estate plan in place, my question is, why not? And maybe you're too busy. And trust me, as a small business owner and a father of 3 young kids, I totally get it. Life is really busy. And if that's the case with you, again, I get it. But I want to, again, celebrate you for being here tonight and taking the time to educate yourself and start the process to get an estate plan in place tonight. Maybe you feel like you're too young. And the truth is, anyone over the age of 18 should have at least some estate planning done. I recently helped a young family where a young father had passed away, just far, far too young. And unfortunately, when he passed away, because of the way that he held his assets, because there weren't certain documents created and certain things done in the right way, he left behind something of a mess for his wife and for his kids. And it's a really sad case, but it doesn't have to be the case for your family. I've helped young people especially young families, and I've seen the relief on their faces and like a weight lifted off their shoulders when they get this done, because it means that they know what's going to happen if something happens to them. And you're really taking care of your families, and you're putting your families in the best position possible for one of their darkest moments and one of their moments of most struggle when they are missing you. Maybe you feel like estate planning is just too expensive. And I get that. And before word processing, maybe that was true. But I can tell you estate planning is more affordable and more accessible than it ever has been. And it's becoming more and more something that middle-class families and middle-class individuals can access and can get done. And in fact, I have some bonuses here at the end today that are going to make it even more affordable to get a great estate plan in place. And maybe you're worried about jinxing yourself. And tonight, I don't see anybody saying that they're willing to admit that they're worried about jinxing themselves. But I see that often, that it feels like the cop who's the day before retiring or something like that, where they just know that if they get an estate plan in place, it's going to be a problem. But I can tell you, I have done dozens and dozens of estate plans, and I've never seen a correlation between having a client get an estate plan done and having something happen to them or happen in their family. I just haven't seen that correlation. So I can put your mind at ease a little bit there in case you are worried about jinxing yourself and you just don't want to admit that that's the case. But I'm seeing a lot of people who are worried that this is too expensive. And I want to tell you that I'm going to speak specifically to what the fees are for estate planning. I'm going to talk about what the costs are for trying to do a do-it-yourself plan, what fees you can generally expect to pay for a traditional estate planning attorney, and what fees I ask for when I work with a client to get an estate plan in place that's really going to protect their family. So I'm going to talk about all of that tonight. Again, stay with me. I promise it's coming, and I look forward to sharing that information with you. So I did see that there are some people who do have an estate plan in place, and I'm curious, what do you want to learn here tonight? And even if you don't have an estate plan in place, maybe something on this list sticks out to you or resonates with you and is something that you want to talk about. Also, if you post in the chat, I'll be able to see those questions as well. And so maybe something that you want to talk about isn't on this list. But if you want to know if an online will is okay and is going to protect the people that you love, I'm going to speak directly to that question tonight. And maybe you did a plan, but it was years ago, and you were naming guardians for minor children that now have minor children of their own. And you're wondering, is that plan outdated? Is that too old? Do I need to do something else? Do I need to figure out something else? And estate planning really is a living subject. As things change in our lives, as the law changes as well, oftentimes it makes sense to update our plan to make sure that we are considering the current circumstances. Maybe you want to know, maybe you did have an estate plan done, and the attorney that you work with didn't take the time to educate you, wasn't really empowering you, was kind of just making the decisions for you and pushing you along a path that you didn't completely understand. That's something I've heard from a lot of my clients that they've experienced from other attorneys, this kind of will mill or document mill type of attorney. And now you want to better understand the plan that attorney put into place. And I can tell you, I will definitely speak to that tonight. My goal here tonight is to educate you. I love doing it. And to that end, again, if you have questions, I hope that you'll post them in the chat or in the Q&A so that I can respond to them. I do see somebody's posted, I just want to understand a trust versus a will and why it's important to have and what goes into one. That's a fantastic question, and I am going to speak directly to that here in just a minute. So I'll make sure to answer that question tonight. Another question that I have here is, transfer on death deed is good in Minnesota. It can be used for both joint and single person's property. Is this a good idea for everyone? Or when might it not be a good idea? Do I need to update when a spouse dies? And that's coming from Coon Rapids, Minnesota. It's a fantastic question. Transfer on death deeds are a fantastic resource in Minnesota. And what it does is it takes that home, or it takes that real property, and at the owner's death, it transfers that property automatically to the people listed on that transfer on death deed. And so you can imagine a situation where mom and dad want to leave their one child with their home. They just fill out this transfer on death deed, have it recorded in the county where they're living, and that home will automatically, at their death, go to that child. Now, there's some paperwork that they need to file with the recorder, but it is all much easier and much cleaner than having to go through the court process of probate that we're going to talk about here in just a minute. So a transfer on death deed is a fantastic resource and something that I use often with my clients. But a transfer on death deed is not perfect. And in particular, a transfer on death deed can cause a lot of conflict and controversy in the family when you have multiple people receiving the property. And here is why. Let's say instead of that one child, mom and dad have 3 children. And maybe one of the children has stayed in Minnesota. One of the children is now in Maryland, for example, and one of the children has moved down to Chicago. Well, mom and dad decide to create this transfer on death deed. They want to include all 3 of the children, thinking the kids will receive the property, they'll sell it, and they'll be able to split the proceeds among them. Well, with 3 children, now all of a sudden, 3 people need to come together and meet minds in order to sign off on the sale, just to agree to the sale, which oftentimes is not the case. Oftentimes, somebody, maybe the Minnesota child, wants to live in the house and has always thought that they would return to the family house. And that's why they stayed close in Minnesota. And so now you have some conflict, you have some controversy between those 3 children. What makes it even more complicated is in Minnesota, the spouses also get a say, because real property, spouses have an interest in the real property of their spouse. And so now you have 6 people who get to make this decision. There are much simpler instruments for splitting up the house in that sort of a scenario. And I can tell you, I have seen, or I've heard of scenarios where 6 or 7 kids have all been listed on a transfer on death deed. And it was a mess. It did not lead to the result that the parents wanted when they decided to leave the house to the kids. So that's a fantastic question. Maybe I went into a little bit too much detail, but I really appreciate the question, and hopefully I answered it thoroughly for you. Another question that I have here is cash accounts and IRA and 403B and 457 plans all list beneficiaries for each account. So do or don't they need to have it in a will or estate plan? Beneficiaries need to always list, right? Is this every part of a will or living trust? Beneficiary designations are fantastic because, again, by law, you're able to transfer property to the beneficiary listed. But also beneficiary designations, planning by beneficiary designations can lead to a lot of pitfalls. And in particular, it can lead to pitfalls where people don't receive what you wanted them to receive. And maybe it's because, for example, you have 2 kids and you put each child on one of your bank accounts. But over time, those bank accounts, the checking account and the savings account that started out equal, that started out with the same amount of money in them, all of a sudden the checking account is spent down by half and the savings account is still at its original value. Well, when the beneficiary designation kicks in and it transfers to each of those 2 kids, one of those kids is going to receive half the value of their sibling. And so if equality is something that's important to you, planning by beneficiary designations is challenging and oftentimes will not lead to the best results. Also, beneficiary designations for minor children can lead to a whole host of complications. Minor kids can't receive property directly. And so somebody needs to hold that property, and figuring out who is going to hold that property can really be a tough thing to decide when they're receiving it by beneficiary designation. So great questions again. I just want to let you know, you are in the right place tonight, whether you have an estate plan in place or you don't have an estate plan in place. You're in the right place if you don't think that you need an estate plan, but you're curious about the topic. You're in the right place if you have someone or something that you care about and you want to protect. And you're in the right place if you did an online or fill in the blank will and you're not sure if it's going to work. And you're also in the right place if you're nervous about how much this is going to cost. And like I say, I'm going to speak directly to that point here as we go on with the night. So stick with me. I will get to it, and we'll have that conversation. But the reality is, estate planning isn't about you. It's about the people that you love. And this is something that really occurred to me in particular, but to my wife and I as we were doing our updating our estate plan recently. And these are my 3 kids, by the way. This is Margaret, Ben, and Elizabeth from left to right. That the estate plan wasn't for us. It wasn't going to enrich us. It wasn't going to, bring us added income or anything like that. But it was really for them. It was an investment in them and an investment in a moment in their lives when we weren't going to be there with them, and making sure that we were taking care of them by taking care of our estate plan so that they would be well taken care of by the people that we chose and with the assets that we want them to have if something happened to us. So here's what we're going to talk about today. We're going to talk about planning for incapacity, and we're going to talk about how you can put in place somebody who can make healthcare decisions for you and somebody who can make financial decisions for you. We're also going to talk about planning for when you pass away. We're going to talk about how you can get guardians nominated for if you have minor children under the age of 18 who need somebody to raise them till the age of 18, but also guardians who can stay with those kids in the short term before those long-term guardians can get there. We're also going to talk about probate. Probate is a court case, a court process that your estate needs to go through after you pass away if you die owning assets in your own name. We're going to talk about the time, cost, and public nature of probate. We're going to talk about estate taxes today, and that's something where I usually get to give people good news is about estate taxes, so stay tuned for that, and we'll talk about that. We're going to talk about unclaimed property today. And that's something that you won't hear a lot of estate planning attorneys talk about, but it's something that I think is really vital to talk about, is making sure that you don't lose property to unclaimed, to the state departments of unclaimed property. We're going to talk about intangible assets today, things like your values and your stories, and how you can make sure to share those with the people that you love, even if you can't be there to share them with them, share the intangible assets with them. Before we jump into it, let me introduce you to myself in a little bit more detail and tell you a little bit more about me. So this is my family, and this time from left to right, it is Elizabeth, Margaret, and Ben, and we live in Bloomington, Minnesota. I graduated from the University of St. Thomas School of Law back in 2012, near the top of my class. And the next day, my first child, Ben, was born. So there you can see me commencing from law school. And on the very next day, I got to hold my son for the first time. After law school, I found a job with a small estate planning and tax preparation law firm, and I loved the clients that I was able to work with. But at the same time, I didn't always feel like I was providing the amount of value that my clients really deserved. And so after a little more than 3 years, I ended up leaving that small law firm. And this is actually a picture from my last day there. Someone has to graduate at the bottom of the class. Now, this was not said about me, but it was something that was said about another estate planning attorney. And in fact, it was something that my parents said about an extremely negative experience that they had with an estate planning attorney who helped my grandmother to plan her estate. And there's a big reason that she said this. I don't think it was actually the attorney's knowledge. I think that this attorney was practicing under kind of a broken, kind of a defunct model. But that model leads to these kinds of results, thinking that this person graduated at the very bottom of the class. I'm going to talk more about that faulty model. I call it planning for death a little bit later. But first, let's talk about some aspects of planning for estates. And here I'm going to post the last poll. I guess I left that previous poll running until now. But I want to ask a kind of demographics question, and I want to find out what the audience looks like here. So which of these best describes you? And I know not everybody here has minor kids tonight, but guardianship is so important that I want to touch on it very quickly. Even if you don't have young kids, maybe you know somebody with young kids, or maybe you know somebody that you can share this information with. Short-term guardianship, on basic level, imagine that you go out on a date night, you leave the kids with the babysitter, you don't have a plan in place, and something happens, you're not able to return home. What happens? And what happens is that babysitter eventually is going to notice that you haven't returned, is going to realize that it's later than you said that it was going to be. That babysitter is going to call the police, and the police are going to come to the house, and they're going to have to get child protection services involved. Unfortunately, that's where the kids have to go. There's a lot of liability for the police if they try and give the kids to someone else. And so that's the most likely situation is your kids end up with child protective services. It's not ideal. I know that's not what I want to have happen for my kids. And that's why it's so important to make sure that you document and name somebody as a short-term guardian who has the legal authority to stay with your kids. And also to voice that to your babysitter to make sure that your babysitter knows the first person that you call, if we don't get here tonight, if we don't show up tonight, is our short-term guardian, so that that person can be here and can take care of the kids. And after that, we can figure out what needs to happen. So that's short-term guardianship. There's also long-term guardianship. And long-term guardianship is who raises your children until the age of 18. And if you don't have a plan in place, there is a plan that the state has written for you. And the state's plan for you is a judge is going to decide where your kids are going to go. And probably it's a plan that you're not going to like. And maybe it means that Uncle Larry looks the best on paper. And so because Uncle Larry has a stable job and because Uncle Larry has a big house, Uncle Larry is going to be the one to end up with the kids. I don't know if that's the case in your family, but we all know somebody like Uncle Larry, and I feel so bad for casting shade on Larry, but we all know somebody that we wouldn't want our kids to end up with, that person is just not the person that our kids are going to flourish with, that our kids are going to thrive with. And that's why it's so important, if you are a parent of minor kids, or again, if you know somebody who's a parent of minor kids, that you name somebody as a long-term guardian so that you know who is going to raise those kids until they're 18 if something happens to you. Great. Thank you again for responding to that poll. Not a lot of young kids here tonight. Not a lot of people with young kids here tonight, but that is good to know. So how are people going to receive your assets? Let's take a look at the state's plan for how people are going to receive your assets. And the state does have a plan for your estate, and that plan is a one-size-fits-all process called probate. And probate is really a lawsuit that you file against yourself with your own money for the benefit of your creditors. And probate is slow in Minnesota. In Minnesota, probate takes a minimum of 6 to 12 months, but more often now it's taking something like 12 to 18 months. There are backups in the court and also slowdowns in the process, built into the process itself, so that it takes that lengthy amount of time to ensure that your creditors have time to come forward and get paid. And so probate, again, is very slow in Minnesota. It's very frustrating for heirs and for beneficiaries to go through this process before they can receive their first distribution. Probate's also expensive. There are attorney's fees and executors' fees, appraisers' fees, court filing fees, all these different fees built into the probate process. And so while the state of Minnesota isn't necessarily collecting those fees, you have to pay them in the form of hiring an attorney to get you through the process. And you have to pay them in the form of paying your executor, your personal representative, something reasonable to do the work that's required to get your estate through the process. In Minnesota, we estimate that probate costs something like 3 to 6% of the gross value of your estate. And so you can imagine, if all that you own is a house worth $400,000, which I understand is a nice house, but if all that you own is that house worth $400,000, probate is already going to cost you somewhere between $12,000 and $24,000. And in fact, we're going to have an opportunity to actually calculate your probatable estate and what probate might cost in just a minute, and do some back of the envelope math on it here in just a minute. Probate's also public. So I'm showing you here the last will of Anna Nicole Smith. And wills are, the reason that I can show you this is because wills are totally public. They have to be filed with the court, and the court has to open them up to the scrutiny of the public. The court also has to open up to the scrutiny of the public. You're in an inventory of your assets. Everybody gets to see that, and everybody gets to see who is going to receive those assets, who gets distributions from your estate, and in what amount. And so this is something that is really unnerving to a lot of people, that the state would share this kind of information, but it is a court process. It's a court process that's public and that is open to the scrutiny of the public. And I see I've got another question here. Would there be a probate on a house if a transfer on death deed was filed with the county? The answer to that question is no. If a transfer on death deed is filed, that house transfers by operation of law, and it avoids probate. It goes outside of probate. Again, that's assuming some things like that the transfer on death deed is not pointing to a minor, because if it's a minor that is going to receive the house, there would need to be a conservatorship case that or a conservatorship process that that minor or the minor's guardian would have to go through. It also assumes that everybody on that transfer on death deed survives, or that it's clear what should happen if everybody doesn't survive. So there are some stipulations there, but generally a transfer on death deed is like a beneficiary designation. It goes outside of the probate process. It goes by operation of law, we say. Good question. Here's another thing. If you don't have a plan in place, minor kids, if you have them, will receive assets at 18 and unprotected. And again, they can't actually take possession of those assets at 18. So they have to have, or excuse me, they can't take possession until they're 18. But at 18, they get those assets outright, and the conservator has to hand them over to those kids at 18. And I think that we all know stories about people who received assets or received money before they were ready to handle it. And the financial impact on those people is often immense and not for the better. So here is your opportunity to calculate your probate estate. And here I have listed a sample probate. And I understand that the numbers here may be higher than you're used to seeing, or they may be lower than you're used to seeing. It doesn't matter what the numbers are. It's just an example that we can kind of break down and see a sample probate estate. So here you can see I have a family home listed that's worth $300,000, a rental property that's $250,000, furniture, household goods in the amount of $30,000, all these different things, including a small business interest worth $100,000, and it adds up to $850,000. Now you can get 5% of the gross value of this estate very quickly by moving the comma over one place. So it's 85,000, and then dividing that number in half. And that's where I get this $42,500 as a quick, again, back of the envelope math sort of thing, where we can find out this information, an approximation of what probate might cost. To add in a little bit of a wrinkle, this is what it looks like if you have accounts that are payable to minors. And that includes things like life insurance. If you have a minor listed as a beneficiary on a life insurance policy, or if you have a minor that's listed as a beneficiary on a retirement account, then those amounts also have to go through a court process called conservatorship, guardianship, or be dealt with in the probate process. And so that is going to add to the costs and to the fees that would be collected in that probate. But here is the good news. Probate is totally voluntary. You do not have to subject your family to this process. The only people who need to experience it are people who don't plan. So if probate seems like an issue to you, if you don't want them to have to deal with your heirs to have to deal with that slow process, if you don't want your estate to have to pay those high fees, there is a foolproof way to avoid probate, and that's by fully funding a living trust. And a living trust is a document written by an attorney. It is an agreement, and it's an agreement between yourself and yourself, where you are subjecting your assets to certain instructions in this agreement. And by doing that, by writing this agreement and by fully funding your living trust, you are able to completely avoid probate. And so when I say fully funding a living trust, fully funding an agreement, what does that look like? And this is a slide that tells you exactly what that looks like. If you have investment accounts, things like brokerage accounts or mutual funds, stock accounts, that sort of thing, you actually retitle those investment accounts in the name of your trust, and that gives the trust ownership over those assets. If you have bank accounts, we all have bank accounts, you go down to the bank and you sign new signature cards at the bank that, again, put that bank account into the name of your trust. If you own real property, if you own your home, or if you own a rental property, you would execute a deed in the name of the trust. So you give that property over to yourself as trustee of your trust, and then that property is held in the trust and can avoid probate. You can also transfer stock and bond certificates, again, by putting the trust as the named person on those stock and bond certificates. You assign personal property using something called an assignment of personal property or a bill of sale, so that those assets go into the trust. Personal property is things like your furniture or your clothing, jewelry, that kind of thing. You can do that very simply with an assignment of personal property or bill of sale. Then you change life insurance and retirement account beneficiary designations so that those are pointed to the trust, and that will ensure that those assets also avoid probate, even if the beneficiary, so even if you would have had a beneficiary listed who might have predeceased you, if you point it towards a trust, that isn't going to happen. The trust will contemplate what exactly happens if this person predeceases, this person predeceases. You're not able to do that level of planning with beneficiary designations, as I discussed earlier. All right, here is where I get to give you some good news. We get to calculate what estate tax might be due on your estate. And the good news here is that right now there is federal exemption in the amount of $11.7 million. And so that means for your first $11,700,000, you owe nothing in estate taxes. Now, once you get past that point, the rate is pretty steep. It gets up to 40%, so 40 cents on the dollar above 11.7 million. But again, there is a very generous exemption built in right now, and very few people have the federal estate tax actually concern them or actually worry them. In Minnesota, we also have an estate tax exemption for the first $3 million. So there is no estate tax due for those first $3 million. And it's only when you get above that point that you start paying at 13 cents on the dollar up to 16 cents on the dollar as you continue to go above 3 million. These numbers are also, you can also double these numbers with proper planning. On the federal level, the number is automatically doubled if you are married. So that's $23.4 million that you can pass tax-free from the federal government. And on the state level, if you do some planning and you make sure that specific assets are going in the correct way and are held in the correct way, and you subject certain assets to estate tax when the first person passes away, then you can double that $3 million exemption so that you actually have a $6 million exemption. But that's not something that you can do without planning. That's not something that you can do that just happens automatically. You need to do some planning in order to make sure that you're able to double that $3 million exemption in Minnesota. And so if that's an issue for you, it's something that I can definitely help with. But again, some good news for most of us that estate tax is not going to be an issue. Will your assets be lost to the state? So does anyone have any idea how much money is currently in our State Department of Unclaimed Property? And I know that we do have a visitor from Maryland, but this is for property in Minnesota. Right now, the Minnesota Department of Unclaimed Property has more than $700 million there. And in fact, across the United States, it's something like $58 billion in different state departments of unclaimed property. And the way that the money gets there is that somebody passes away, and not all of it, but the way that a large portion of the money gets there is that when somebody passes away, the heirs aren't sure exactly what mom or dad actually had. They're not sure exactly where mom or dad banked. They're not sure if it was just one bank or if it was multiple banks. They're not sure where the brokerage account was or where mom and dad bought stock through. They're not sure about where different assets are. And because they don't have that clarity, because they don't have things all together in an inventory to make sure that the heirs are able to access it and see exactly where the assets are, things get lost to the State Department of Unclaimed Property. And they can be recovered, they can be claimed later on, but it is a difficult process to go through and make those claims and actually get those assets out of the State Department of Unclaimed Property so that they can get to the people that you want them to. So this is something that's really important. It's something that a lot of estate planning attorneys don't address and don't take care of. But it's something that as somebody with a limited estate right now, I know that this is really important to me, that my kids get every dollar that I have planned for them to receive. It's very important to me because that is the money that they are going to need to live on if I can't be there and if I can't create extra income for them. This is really cool. You can also make your trust a real treasure chest, and you can do that by building in asset protection for your heirs over their inheritance. Asset protection means that their inheritance can't be taken away by a spouse in a divorce, and it can't even be touched if your child is in a car accident or sued at some point in the future. This is something that, again, is really cool. And if it interests you, protecting their inheritance from things like divorce and things like creditors and lawsuits, I hope that you will schedule a time to meet with me because it's something very cool that I can do for my clients right now. So I know this is something that is very difficult to talk about right now in the times that we're in. But it is so important to plan for incapacity and to make sure that your healthcare wishes are known and that the person, the healthcare agent that you want making decisions on your behalf is known and documented. And the person on the screen right now is Terry Schiavo. And in the mid 2000s, Terry fell into a vegetative state as a result of some health procedures and as a result of some things going on with her heart. And Terry was in this vegetative state and had arguments in her family about what exactly should happen to Terry. And so her husband at the time thought Terry would not want to live in this vegetative state. She would want to be let go. She would want to be released from this so that she could pass away peacefully. And that's what Terry would want. Her parents thought Terry would want to fight for any chance possible that she might come out of this vegetative state. And this led to a lot of conflict in the family. It led to court cases. It led to conflict across our entire nation as we watched Terry Schiavo's case unfold. And we all weighed in with our own thoughts and concerns about what was happening. But Terry could have avoided that situation by clearly naming the person that she wanted to make healthcare decisions for her and clearly laying out exactly what those healthcare decisions looked like. She could have created clarity for her parents. She could have created clarity for her husband so that they wouldn't have had that conflict over that moment in her life. So we've talked about a lot of things today. We've talked about probate and we've talked about estate taxes. We've talked about incapacity and we've talked about unclaimed property. We've talked about making your estate or giving asset protection to the inheritance that you give to your heirs so that it really is protected from divorce, from lawsuits, from pretty much anything that anyone can throw at it. So what can you do today to do the right thing for your family? And what should it cost to plan right? And so really you have a couple of options here if you want to get a plan in place. You can either do it yourself or you can work with a lawyer. And keep in mind, not all lawyers are the same. And I'm going to speak specifically to that here in just a minute. But how do you choose? Would you benefit from working with a lawyer? And if you own more than just your personal belongings, things like cars, clothing, jewelry, furnishings, if that's all that you own in the world, you might be okay to do it yourself. But if you own more than that, if you own your home, if you own investment accounts and bank accounts with significant assets in them, if you own retirement accounts and life insurance policies, if you own a business especially, then you really need to work with an attorney to make sure that the estate plan that you have written is going to work when you need it to work. If you want to ensure that the people that you love are going to stay out of court and out of conflict, and that they would have somebody to turn to when something happens to you to guide them through the process and to make everything okay, then you need to work with an attorney. If you want a kids protection plan, which includes short-term guardianship and long-term guardianship, if you want to avoid probate or estate taxes, or you want to protect your children's inheritance with that asset protection, then you have to work with a lawyer. Those aren't things that you can do yourself. They just aren't. So you really need to work with an attorney to get those in place. And if you want to be guaranteed that your plan is going to work when you need it to work, then you really have to work with an attorney. And another thought, if you want to give your assets to someone other than your kids, and this happens sometimes, maybe you want to give your assets to charity, maybe you want to give it directly to grandchildren, maybe you want to exclude a child from receiving assets because of the relationship that you have with them or some difficulty in their life, then you really need to work with an attorney. And this idea of do it yourself, I have to say, I am a huge believer in do it yourself generally. And in fact, it was last year before the fishing opener, I was getting the rods ready for my son and I to go out fishing, but we had just gotten a new rod and reel. And so on this new rod and reel, I had to put fishing line on for the first time. And I worked at it. And I don't know what I did wrong. I don't know if I wound it the wrong way or what it was. That would be super embarrassing if I did that. But whatever I did, after I thought that I had gotten the line on in the correct way, and I went to put everything away and to get ready to go, all of a sudden that line started jumping off of the reel, and it was everywhere and a huge tangled mess. But that wasn't a big deal. All I did was cut off the fishing line that had jumped off and that had gotten tangled and that had created that mess. And the rest of the reel was still already good to go. And all I lost was, 25 cents in fishing line, something like that. Not a problem. That was a great do-it-yourself project because the costs were really low for failure. And I knew right away, I had tangible evidence that I had failed as soon as it happened. Estate planning is not that way. Estate planning, you're not going to know if your estate plan is going to work or if it's going to fail until after you're gone and until after it's too late for you to clean it up. And that's why I think it is so important to work with an attorney. It's so important to work with somebody who knows the ins and outs and who knows whether your estate plan is going to work or not. Estate planning mistakes are costly, and I have seen families bear those costs after they've lost a loved one, and I've seen the resentment sometimes that it can cause, but just the hurt that it can cause as well. So you probably know by now whether you would benefit from working with an attorney, and now you need to consider the kind of attorney that you want to work with. Someone has to graduate at the bottom of the class. I'm bringing this back up, this quote from my parents about this other estate planning attorney, again, not myself, that had failed so badly when my grandmother passed away. And again, I don't think it was about the intelligence of this attorney. Maybe it was, but I think that this attorney was operating under a faulty model, again, that I call planning for death. And this is what that model looks like. The typical experience of working with an estate planning attorney Most estate planning attorneys, unfortunately, are still stuck in this traditional model. But most attorneys will work from form documents, and they believe that they're just kind of set it and forget it documents. You come in and you fill in some boxes, and the attorney doesn't really explain it completely, doesn't educate you, doesn't empower you to make the decisions that you need to make in the estate plan. And so after they've filled in your name on these documents and gotten you to sign at the bottom, they figure it's close enough, right? And kind of send you on your way. So you take those documents, you don't really understand them, you just stick them in a bottom drawer and you don't look at them again. Unfortunately, when those documents are needed, that attorney hasn't done the job that's necessary to make sure that you were educated and empowered to make those decisions for your family, and they are probably going to let your family down. Typical experience isn't going to keep your money out of the Minnesota Department of Unclaimed Property. And the typical experience might avoid probate, but it might not. Again, those form documents that you put down in that bottom desk drawer, do you know what that says, and do you know what it means? And did you fully fund the trust that may have been created with those documents, or did those documents even include a trust? A lot of estate planning attorneys have just given up on writing trusts because they aren't able to provide the guidance and care to make sure that their clients fully fund a living trust. And so they write will-based trusts for their clients because they know that when that person passes away, they're going to be able to handle the probate for that family. And that's not serving those clients. It's not serving their families. It's not making sure that they're taken care of in the way that they need to be taken care of. But it's something that unfortunately is all too real right now. Typical experience is only going to focus on the money. It's not going to focus on your stories and your values and making sure that those are passed to the people that you love, to your heirs. Typical experience is going to leave assets to heirs unprotected without that asset protection that I was talking about earlier. In the typical experience, you're not going to have ongoing legal guidance because a typical estate planning attorney is going to charge hourly fees. And so you aren't going to want to reach out to that attorney when they're charging you $350 or $400 an hour to ask them questions, because you know that you're going to get a bill in the mail 2 weeks after you ask them that question. And the typical experience does not adequately protect minor kids. It doesn't make sure that they're protected in that short term before the long-term guardian is able to take custody of them. And so it can leave those children going to child protective services, even when that's not what the parents would want. And the typical experience is really going to leave you with the question, is this going to work when I need it to work? And that's not a question that you should ever have after working with an estate planning attorney. The estate planning attorney should take the care and the time to make sure that you're fully educated about your plan and that you know that it's going to work when they need it to work. And that's why planning with me is completely different. It's a totally different experience. Planning with me, all you pay is a flat fee, and you actually choose the fee. And that doesn't mean that you just pay me a goodwill offering, but I have fixed rate flat fee packages, and I will help you. I'll make sure that you're educated and empowered to choose the fee that is going to correspond to the package, estate planning package that your family is going to need and that you want them to have after you're gone. Planning with me, you're going to make sure that you keep the money out of the hands of the state, out of the hands of that Minnesota Department of Unclaimed Property or whatever state you're in, the Department of Unclaimed Property. Planning with me, you can protect your kids totally in the immediate and in the long term until they're raised, until they're 18. Planning with me means that you're going to be able to keep your family out of court conflict. I believe so strongly in that. At heart, really, I am a peacemaker, and I believe it's so important to protect the family from court and conflict, especially after they've lost the linchpin that was holding them together, and that linchpin is you. Planning with me means that you're going to know that you've made the right decisions, because again, I believe in educating and empowering my clients, not making decisions on their behalf. Planning with me means that you can protect the family money from outsiders. And planning with me means that you're going to have a lifetime of guidance and protection. It's really a gift that you're giving your family when they need it the most. So what should this cost? What should putting an estate plan together cost? And I told you we would get to this But before I give you exact numbers, I want to set a little context. And so if all that you have is a house worth $400,000, again, I recognize that might be a pretty nice house, but I'm saying if all that you had is a house worth $400,000, 3% of the value of that house is $12,000. And that's a pretty lowball estimate of what probate might cost if you have a house worth 400,000. If you have assets over $3 million, doing this planning will save your family at least 3 cents on every dollar over 3 million. A typical estate planning attorney, a typical attorney who is planning for death and might not keep your family out of court and out of conflict, definitely isn't going to ensure that your assets aren't lost to the State Department of Unclaimed Property, and is only going to plan over the money, not your kids' immediate care, not your values, not your insights, your stories, experience, all those most valuable intangible assets that are often lost. A minimum you would pay for that kind of typical death plan with an attorney is $1,500, and that's at a very minimum. Or you can meet with me. I'm a personal family lawyer, and what that means is that I stay with you for your lifetime, and I'm available for your family. And you can learn specifically what your family needs, and you can even choose your own fee, again, based on the flat fee packages that I have, likely to range somewhere between $2,000 and $8,000. And you're going to know that your plan is going to work when your family needs it to work. And again, I want to make this super easy for you. And that's why I am moving things around so I can post this link in the chat box here for everyone to see. This link is a link to my scheduling page, and you can click through and see exactly what I have available. So click into that link and then click on Family Wealth Planning Session, because that's where I want to meet you. That's where I want to have an in-depth conversation with you about the people in your family and about your assets and about planning for them in a way that's really going to take care of them and make sure that they are taken care of after you are gone. I want to give you that Family Wealth Planning Session absolutely free. And that Family Wealth Planning Session has a value of $750 because it's a 2-hour-long working session with me where we're going to talk about your family. We're going to talk about your family dynamics, and we're going to talk about the assets that you have. And I'm going to bring my knowledge about estate planning and my knowledge about probate, and I'm going to tell you how it applies. I'm going to tell you what the state of Minnesota wants to do for your assets and for your family. And we're going to talk about, in the specific, what is it going to mean for your family and what is it going to look like? I want to give you that initial consultation, that 2-hour-long initial consultation, for absolutely free because you've been here with me tonight. All that I ask is that you do a little bit of homework ahead of time, and that homework is so fantastic. It's going to make you more financially organized than you've probably ever been by the time that you're done completing it. But all I want you to do is complete that little bit of homework, and I will give you that Family Wealth Planning Session for free. And trust me, you'll be very clear after that Family Wealth Planning Session on exactly what is going to happen with your family. And if it's a situation where you're happy with the state's plan for your family, then that's fine. There's no obligation to continue on with a plan after that Family Wealth Planning Session. But I will tell you, most people do continue on and do write a plan for their family that's going to take care of them and that's going to make sure that they're well taken care of if something happens to them. I also want to give you an added gift. I want to give you $250 towards the estate plan of your choice if you reserve your appointment before the end of the week. And all that means is clicking through where it says Family Wealth Planning Session and finding a time on my calendar that works for you. My guess is that I'm probably already booking into November. It may already be the second half of November. But all I want you to do is click through, find a time that works for you, and input your information so that you can get on my calendar and we can schedule to have that meeting. And again, I'm happy to give you that $250, and I'll tell you exactly why. Estate planning is a momentum thing. you have to keep the momentum going. You took the time to be here with me tonight. You've been with me for 55 minutes now, at least. And you've educated yourself about estate planning, but you've got to keep the momentum going, or it's so easy to let it drop off of your plate or to let it drop off of your to-do list and not get it taken care of. And that's why I want to give you that gift. I want to give you that $250 to motivate you so that you can continue on through that family wealth planning session and getting an estate plan in place for the people that you love. And I will follow up with you. But if I have to continue following up with you after the end of the week, just know that the 250 won't be there, but I'd still love to work with you. But I do want you to take advantage of that $250 towards the plan of your choice. So those are your next steps. Schedule your free family wealth planning session with me. Again, I want to educate you and tell you, I want to speak specifically to your situation and make sure you're absolutely clear on what's going to happen with your family and with the people that you love. So I really want to be able to meet with you one-on-one where we can do that, or with you and your spouse if you're married. I do see a question here. It says, my wife and I have separate living trusts. What assets should be put into whose trust? And that's a fantastic question. It's a question that is very specific to the context of your relationship and the assets that you hold. My guess is that some of your assets are already treated as separate assets. Maybe somebody brought assets into the relationship that they received that are treated as separate assets, or maybe they inherited an asset from somebody that is treated as a separate asset. And maybe that's not even the case, because it is not uncommon in Minnesota for estate planning attorneys to plan with separate trusts for married couples. Most of the planning that I do involves a joint trust for married couples, because that's how most couples hold their property and think about their property. But if you have separate living trusts already established and you're not exactly sure what assets should go into which one, I hope that you will schedule a time to talk to me, either a 15-minute phone consultation or the full 2-hour family wealth planning session, where we can review that trust and we can go through and make those kinds of decisions about exactly which asset should be in which trust. But there are some things that you want to take into consideration, especially the value of the assets, that oftentimes you want to try and balance the trusts so that they have about the same amount of value. But there are other things that you want to take into account, like estate taxes and step up in basis that really complicate that question quite a bit. And so it's going to be best if you reach out to me and we can speak to the specific context and to the specific fact pattern that you have. So I hope that you will reach out. So again, I hope that you are clicking through and taking a look at my calendar, and that you are going to schedule that family wealth planning session with me. Again, I'd love to meet with you. I'd love to be able to talk to you one-on-one and learn about the specifics of your situation so that I can help you out. What does a family wealth planning session look like? Well, a family wealth planning session can be totally virtual. In fact, that's how almost all of my family wealth planning sessions have been now since the start of COVID. But really, we start by getting acquainted and learning a little bit more about each other. And as we learn about each other, I'll ask you some questions about your family, and I'll ask you some questions about your assets, so that I kind of get a picture of what is going on in your life and what is important to you. Then we'll start talking in more depth about some specific estate planning topics. We'll talk about who is the person that would collect everything for you if something happened to you. And oftentimes we know somebody like that. We know somebody who's an organizer, or somebody who, would be a good person to step in and be able to collect everything for you. And we'll talk about what would happen if you became incapacitated. What do the court procedures of guardianship and conservatorship look like? What's the cost? How much time does it take? How hard is it to get somebody nominated? Why are they so rife with conflict, those guardianship and conservatorship court cases? we'll talk about that. And we'll talk about how easily you can put in place a power of attorney and a healthcare directive that name who can make financial decisions for you and who can make healthcare decisions for you if you become incapacitated. We'll also talk about what probate will look like for you and for your assets and for your family. And we can get really clear on that in the specific talking together, because I can ask you questions about your family and you can tell me more about it. You can tell me more about your assets and what you have. We can talk about whether or not you're going to owe estate taxes and what your estate tax burden might be. And we can talk about ways that we can plan around estate tax, or ways that we can plan to have additional assets available to pay those estate taxes so that the burden isn't on your estate, isn't on your kids, that you're able to pass everything that you have now onto the people that you love. We'll talk about how the people that you love are going to receive the assets. One recommendation that I have a lot of recommendations, but one of the top recommendations that I have is not to let 18-year-olds receive money outright. It is just not a good idea. I think I was a pretty mature 18-year-old, but I can tell you exactly what I would have done if I would have received an inheritance. I would have gone out and I would have bought a Corvette and I would have driven really fast, just because that is where I was at 18. I mean, that's how most 18-year-olds are, right? But that's exactly where I was. And I think most 18-year-olds are not in a better place than that. Although I don't know, maybe I'm prejudiced since I thought I was so mature or something. We'll talk about all those things in the family wealth planning session. And again, I'm really happy to do that. Even if you're not sure that you're going to continue with the plan, even if you're not sure that it's something that's important to you at this time or something that you have budget for, again, I hope that you'll meet with me because it's a conversation that I love to have. I love to educate people. I love to help them get clear on exactly what is going to happen in their family, and just give some relief, because I think there's a lot of relief that comes when you actually know. When you know what's going to happen, it just gives people a lot of comfort. Let's see here. I don't want to lose my chat box in case I have other questions coming in. I've totally lost my chat box. Maybe not. Okay, there we go. Okay, now I can see. I don't see any other questions coming in. My link is still there. Some questions that I have had in the past. One question that I often get is about special needs trusts. And a special needs trust is for somebody who is receiving assets from the government, that they have some kind of benefit from the government. Maybe the government is helping to pay for their living. Maybe their government is helping to pay for their healthcare or for their food, something like that. And if they receive inheritance, if they receive assets outright from an inheritance, receiving that money can actually kick them off of that government benefit. And so a special needs trust is a special kind of trust that can hold the assets for that person and make sure that the assets are there for them to enjoy without jeopardizing the government benefit that they're receiving. I see somebody saying here, what is your phone number? And I'm just going to post it here quickly, 952-215-4707. I see somebody saying, thank you, TJ, you were amazing and great info. Oh, thank you so much. Happy to provide the information. I see somebody saying, when would a trust be important? How much money would you need to have a trust? And again, a trust is important when you want to avoid probate, because it's the foolproof way to avoid probate. And it's the clearest way to set out exactly who you want to receive and how you want that person to receive. And so if probate, when we talked about probate, we did that back of the envelope math. If probate seems like an issue for you, if it seems like your estate is going to have to go through probate, then I would really strongly encourage you to consider a trust. It's not right for everybody. And there are plans that I've written that I feel very good about that I have done that haven't involved a trust. But generally, if you own assets, if you own a home and you own assets aside from a home as well that are significant, even over 200,000, over 400,000 certainly, I would strongly encourage you to consider having a revocable trust or a living trust as part of your estate plan. And that's something that we can really talk about in the specifics as well, something that we can talk about together, and that is always covered in a family wealth planning session. We talk about whether it's important to have a revocable trust or a living trust, and whether probate is going to be an issue for you and really an issue for your family. Ongoing costs. How about when a parent dies and leaves you farmland? How much how much to update the addition of farmland? That's a really good question. And so if your question is about adding farmland to a trust, the only additional cost there is making sure that you record the deed, or you record the transfer deed to put that farmland into the trust. So that is not a huge imposition, or it's not a huge cost. Adding assets to a trust is not a huge cost. That's pretty easy to do. A lot of times it's my clients are taking they're the ones doing the work to make sure that things get funded into the trust, with guidance from me, because that is so important, that you have the full guidance from me, that you have all of the information about exactly how to do it and exactly what needs to be done. So if that's the question here, is how much to update, how much to add farmland to a trust, it can be done pretty easily by writing out and executing that deed, and then recording it with the county recorder. Any other questions that people have, please go ahead and feel free to post them. I see that some people have taken advantage and have scheduled family wealth planning sessions, and I got to tell you, I'm so excited that that we're gonna have some meetings here. I hope that more people are looking at it or considering it. I will be sending out some emails. I told you at the beginning that I would be sending out the recording of this webinar so that you could review it if you want to review it, or you could review specific questions or parts of it if that's what you want to do. And so part of that email as well will be the link to my scheduling page, where you can schedule with me and get on my calendar. Again, I want you to claim that $250 towards the estate plan of your choice. But in order to do that, you have to schedule by the end of the week. And when I say the end of the week, I mean the end of the day, Saturday. That's when I want you to schedule by. Somebody else just submitted their preferred time. That's fantastic. And I understand if you need to talk to if you need to talk to a spouse or something like that, I want to give you that time, which is why I give until the end of the day, Saturday, in order to get your name on my calendar. Would you need a lawyer from the state that the farmland is in? That's a fantastic question. And yes, you do want somebody from that state to be able to write the deed and make sure that it's executed properly, or that it's recorded properly as well, because that is so important. You don't want to screw that up. You don't want to leave that property outside of the trust and end up having an ancillary probate or a separate probate opened in that state. And I see that the farmland is in Nebraska and Iowa. You really don't want to have to open probates in multiple states, because the expense of that just multiplies and just gets very expensive. And that's what needs to happen when you own property in multiple states. So yes, you would want to work with an attorney, and you would want to work with an attorney like myself. I have a national network of attorneys that I can draw on, and I can draw on their experience to either co-counsel to create that deed and make sure that the land gets into the trust in the proper way, or I can refer to an attorney in that state to make sure that they're able to handle it in the right way and make sure that everything is done properly, so that it's held in the proper way, so that it doesn't have to go through probate. Well, I am just about to lose my voice here. I don't know if you can hear that or not, but I think I'm probably going to call it here, unless anybody has any additional questions that I can answer before we get off of the webinar together. I got to tell you, I am so glad that you chose to join me tonight. I'm so glad that you have been a part of this. and that you have educated yourself and taken the time to be with me so that you can be educated on this topic. I'm really passionate about this topic. I love educating people and empowering people on this. I think that's about the 30th time that I've said that tonight. But know that you can reach out to me. You can reach out to me by getting on my calendar and setting up a time where we can meet, either for that full family wealth planning session or for a shorter 15-minute phone call. I would love to meet with you. I would love to talk about your specifics and make sure that you are very clear on exactly what it means for your family. Again, I'm just really passionate about this. Saying thank yous. I'm saying thank you for the time and sharing all the info. Hope you have a great rest of your night. Thank you so much. Thank you, everybody. I have really enjoyed being with you, and I hope that you've enjoyed being with me as much as you can at 7 o'clock on a Wednesday night. I hope that you have a great night. Take care.